So we are live now. So just to state, there were three sectors traditionally that were always kind of unregulated. The first one being securities broking. So that was originally ages back unregulated. We had real estate, which was also kind of unregulated, and the third one related to diamond trading and how diamond business is carried on. Traditionally, all these three sectors were always unregulated. So the first to be brought in line because of various schemes and the first to be regulated was the securities broking, right? With the coming into force of SEBI and SEBI brokers regulations, the brokers were put under the net of regulation. Then we had in 2017 the Real Estate Regulation Act, where we brought the real estate business and also real estate broking, okay, which was either to unregulated under the RERA or the Real Estate Regulation and Development Act. And ever since, even from 2017, there were projects which were ongoing, which were continuing, which were required to be brought under and, registered with RERA. And this registration itself was fraught sometimes with so many issues that, people were unclear about a lot of things. Okay, they weren't sure how to go about this registration, right? So to deal with some typical issues which developers or builders face while registering their projects under RERA, we have with us Mr. Mohammed Zain Khan. Mohammed, a very warm welcome. Is he here? I think we have lost the speaker. Just give me 1 sec. I'll bring him back into the webinar.
Hello. Komal,
yeah, now we have you here. I am so sorry about that. There have to be so many Zoom controls with us because we sometimes get security issues. But if you are careful, you don't. So welcome, Mr. Khan. And just to introduce, he is an alumnus of Mumbai University, and he has been a senior associate with Little and Company, which is a quite famous law firm. And he has handled a lot of real estate related work, including registration, structuring, transactions, redevelopment related work. And we he has kindly agreed to share his views or share the issues that people face with respect to registration of real estate projects with us. And I can also proudly say that Mr. Khan is an alumnus of the Law Seco RERA course. I'm very happy to welcome you, Mr. Khan. Okay, so let's have a bit of an introduction from you. Like, what are the kind of projects that go for registration? What is the distinction mainly between ongoing or under construction projects and new projects when it comes to registration?
Am I audible, Komal?
Yes, you are.
Yeah. So basically, this discussion for today, it can be divided, as you said, it can be divided into two parts: registration of a new project, which a developer per se promotes fresh, and in also projects which are ongoing. So ongoing projects are those projects for which the completion certificate or the occupation certificate has not been received. So if you see with respect to a new project, which is now being promoted market afresh by the developer, then there is no difficulty, as in, a lot of guidelines and the law and the functioning of authority is quite clear with respect to registration now. So per se, with respect to those projects, there should not be any difficulty. because the process is a completely online process where the developer has to, under section 3 read with section 4 and rule 3 and 4 of RERA, Maharera rules. I'll be talking particularly about Maharera because I deal with a lot of projects in Mumbai and Maharashtra, and I am more conversant with the rules and procedures of Maharera. So the developer will have to make an application under section 4 read with rule 3 and section rule 4 of RERA. So this rule section 3, just an overview. I don't want to get this topic to be very theoretical, but once this is understood by the participants, then the queries and the issues that can be faced are much more clearer, and we can have questions with respect to that. So
Yeah.
Under section 4 read with rule 3, the promoter has to provide a lot of details with respect to his enterprise, his title to the project, and layout plan, approved plan, permission from the competent authority, commencement certificate, the nature of the project, the title of the project, and what is the FSI that is being used, the layout of the plan, what is the development going to look like, the amenities, etc. So all these, there is a comprehensive list of details to be provided by the developer for seeking a registration of a real estate project. And under section 4 is where the developer has to provide or disclose that what is the balance in respect of ongoing project. This is not for a fresh project, but in respect of an ongoing project, the developer has to disclose that what is the amount of work that he has carried out in respect of sanctioned plan with respect to an ongoing project, and what is the development time that will be taking place, how much time he wants more, and he has to disclose that what was the original timeline provided to the purchasers. And then, of course, he has to provide a certificate from the CA, from the architect, and the chartered accountant stating that what is the incomplete leftover percentage of work, what is the amount of work what is the amount that has to be incurred for the work, cost, or what is the incoming, or what is the amounts that have to be received from the purchaser. So once all these in respect, as you said, in respect of a new project, once all these disclosures and details are provided by the promoter, necessary fees has to be paid. The size of the project, which is minimum 50,000 to maximum 10 lakh rupees. So once that is paid, there is no difficulty as such in registration of a new project. But of course, the difficulty arises when the project is an ongoing project, and when the project has not received completion or occupation certificate prior to the act coming in force. So there are quite a few issues that I have faced with the ongoing projects. The first that I would like to discuss is a project where I was called upon to register a project in Raigad or New Mumbai. So this project was, I can't hear you, Komal. Am I clear?
That's because I was on mute, so no issues.
Okay. So I was called in to register. I was requested to register a project in New Bombay. The area of this project was around 200 acres. And this land parcel was not a single piece of land, but was amalgamated, constituting various pieces and parcels of land. So the developer, this project was promoted and floated somewhere around the year 2006. And the developer had, at that point of time, sought necessary permissions from the owners, entered into a development agreement, taken a power of attorney for obtaining necessary permissions, NA permissions from the collector of the district, etc. So all these were in place, and the project comprised of various NA plots, which are layout plots measuring from 3,000 to XYZ area. And there were bungalows, of course. So the difficulty now lies in the fact that most of the areas that the developer has in the project has been sold off. The saleable component has been sold off. And only around, say, 50, 60 projects, 50-60 components are now to be sold off by the developer. But the developers, since the law being in place and developer being a compliant, RERA, wants his project to be RERA compliant, the project has to be registered. Now difficulty lies in the fact that the development agreement which was entered into with the promoter was with various purchasers, various owners, which were like 20-30 owners. And they had an understanding, the developer has necessary permissions, but this development agreement is an unregistered, unstamped agreement. So now, as per Maharashtra Stamp Act, it becomes an impossibility that a document like this can be exposed in public domain. Because we all are aware that an unstamped document can be impounded by the collector of stamps, and there is a provision of penalty which is around 300% of the stamp duty not paid. And it also, there is quite some difference of opinions between the collector of stamps also as to what is the rate on which the stamp duty they will impose. Sometime in the exercise of power, they default and they take wrong decisions. They may say that it is in the interest of revenue, but in the interest of the developer, who wants to register a project and pay stamp duty, it may not be feasible. So difficulty now lies that this document, now the developer cannot now go back and register the agreement. Because then this implication of impounding will come in. Plus, with impounding, there will be a difficulty of penalty, and this process of impounding by itself takes a lot of time. That the concerned registrar collector may impound the document, but the period during which he will do the adjudication and he will give you the penalty amounts and how this has to be regularized, it can vary depending on the concerned offices, and it may take around say 3 months, 6 months, or even sometimes years in cases, which I have faced in prior experience with not respect to registration, but with respect to some other documents which were to be impounded. It's a very complicated and a complex process, and plus there is a threat of penalty being levied by the registrar. And the difficulty here is that the developer has only a few areas which are to be sold off. So now comparing his profits with the amounts with the process that he has to go in and the amounts he has to pay, it becomes a virtual difficulty in today's time that how this project has to be registered. So this of course this is one of the projects that I have come across. But there are various projects, even to my knowledge, which have been floated by promoters in the year, say 2008, 2010. And such difficulties are,
more than 10 years like down the line. So like still.
Yes. A lot of, if you see, Komal, a lot of projects which have been promoted in the year, say 2010, 2012, because of a change of the policies of the government and the new DCR. A lot of projects have been on a standstill and are still lying incomplete even as on today. You see Maharashtra, you see Noida, you see a lot of other places. A lot of projects are even going on for 10 years now. In fact, I am as a purchaser suffering consequences of not getting possession from quite a few builders. I have myself taken some office premises, some residential premises. So it's been 10 long years now that we've been undergoing this trauma and mental agony for now. So this is one of the issues that I have faced more particularly while registering a project, and I am still in the process how to find out a way to overcome this issue of impounding and levy of stamp duty and register the project. But in the meanwhile, what happened is we all know that this COVID-19 issue cropped up, and for the last 45-50 days there is not much movement, except of we having some productive webinars and discussions that are taking place on the net. So
but you are in a unique position here because you are on both the sides. Like you get the builder's point of view as well, like the kind of difficulties they actually face really. And you obviously empathize with the home buyers and the office buyers as well, because you yourself invested in a project. So that's that's something that's a little bit different. Like you get both the sides of
Yeah.
the coin.
Yes. In fact, while doing all the litigations that I am handling or dealing about with, I think from both the sides. Even from a perspective point of view and from a purchaser's point of view. And in spite of not being very keen and interested in the field of law when I studied law, but I was all through the while I was connected with the real estate industry. So I knew about the problems that were going on or the issues and, how this industry works and stuff like that. But later down the line, I find myself being fully associated with the industry and, solving problems and, advising people how to go about it.
Yeah, right, right. So, like coming to that issues, given that there are very real practical issues that builders face, is it possible for you to kind of apply to RERA? And are there any provisions or any chances that you can actually put through your real practical difficulties before the RERA and kind of get an extension to register your project or get a solution to the real difficulties, or that doesn't happen, like it is more of an executive office where you will be like it's not something that you can actually reach out to, and you will be penalized in any event.
See, my experience with the authorities over here is that although you can file complaints, a purchaser can file complaints under Section 3 read with Section 4 and 31 for non-registration of a project. So, if you are aware, I was the first person who filed a writ petition against RERA for seeking directions from the Bombay High Court for registration of entertaining complaints of unregistered projects. So, in my experience, purchasers can file complaints before RERA, and those complaints are being heard and decided. But the authority is taking a view that once all these compliances specified under Section 4 read with Rule 3 are in place, only then a project is being registered. So the instances of levy of penalty under Section 59 are very less, as I have seen with my practical experiences. That issue is not taken up. In fact, a lot of aggrieved persons are of the view that that penalty should be levied on defaulting developers and erring developers, so that the projects can be registered and the reliefs reliefs that the purchasers are seeking can be taken up. So as such, as on today, there is no hard and fast whip from RERA that you have to come and register the project. It's only in the case that in the event that the developer is marketing, promoting, then, or if it's an ongoing project and it has not been registered, then you can file a complaint for seeking action with RERA. And when it's a normal course of time, when a developer in the normal course, when the developer wants to register the project, then he has to come forward with all these compliances, and that is when a project is registered. So in fact, a situation in sometime down the line, a situation may arise that people may approach the court against developers for not registering their projects and seeking action, from the authority that these projects are not registered and action should be taken, stuff like that.
Yeah, exactly. So what happens in that case, like if someone actually goes ahead and complains to the RERA, what exactly will RERA do? And then what are the situations where the builder can actually put a practical case forward and say that, look, I cannot register in this particular case, or this is how I am placed?
See, there are a few days back, in fact, just a week back, I got a request from a client stating that he has purchased a flat in a project in Bandra, and it's almost been 10 years and the project is not registered. So he has filed a complaint under Section 3 for non-registration. But in that case, what happened is that the developer earlier, the project which was being promoted by the developer was a small project. Subsequently, in these years, he acquired a lot of adjoining land together, and now that project is a amalgamated or a huge project. So he has come before the authority and he has said, see, this is what has happened. The earlier project is not actually what it is, what it used to be earlier on. And I have acquired a lot of land in the vicinity, and the area of the land has increased. The permissions which are required to be taken in this, there is also a compliance of CRZ. I think this project is somewhere close to the, and he gave an undertaking before the he will register the project within
Mohammed, the voice. We lost your voice
which was accepted by RERA. No penalty developer.
Yeah, we lost your voice for a few seconds.
I got it. So the developer came before the authority and said that he would be requiring further permissions and enhanced permission in respect of the larger project, and he needs CRZ permissions, etc. So all these permissions, he said that he would be able to get in within a period of 8 months, and once he goes for promotion and marketing, he would register the project. But difficulty in such a approach lies with the fact that already, in spite of given this undertaking, the developer has not registered the project. So that does not mean that the purchaser has to be in the foray forever and wait for the developer to register the project, after which the of such projects. The concept of, according to me, concept of registration of a project is completely immaterial to hearing of complaints by the authority. You see section 31, it's very clear. It went against a particular developer or promoter the provisions of RERA by raising his grievances before the authority, which is not the case.
Mohammed, your voice is cracking still. Your voice is still cracking. I believe if you probably if you switch off the video, it might be better. If you switch off the video, the voice might be better.
Okay. The difficulty that I am facing is that my Wi-Fi connection has somehow gone through, and I am connecting through my cell network. My cellular network.
This is better, but now this is fine. Now we can hear you.
Okay.
So I guess if you switch off the video, because if it's on the data, if you switch off the video, the audio will be very clear.
Okay.
Yeah.
Clear now?
Yeah. That is much better. The audio is very clear.
Perfect. Yes, I can hear you perfectly now.
Yeah. So there are a couple of questions here. Someone is asking, what if someone buys a non-RERA project despite it being mandatory? So what's your risk of buying an unregistered project? Is buying a unit rather in an unregistered project? So you lose the protections that the Act provides you as an allottee, right?
Of course, as I said, that complaints as of now are being entered in only respect of a registered project. So supposedly you enter into agreement with the developer who says that he will give you possession down the line, 1 year down the line. If he fails to so, then your complaint might not be entertained. Although it has to be entertained, but it may not be entertained, and you may not be having a remedy with RERA. And then in that case, you will have to approach maybe a civil court, but that also becomes a difficulty because the Act under section 79, I think it bars that civil courts bars the jurisdiction of the civil court. And then your remedy will be with the consumer forums. So which may depend on the pricing. There are quite a few constraints in approaching the consumer forum. First of all, you have to be a consumer. The unit has to be a residential unit. It has to be for self-use. It is not to be for a commercial purpose. The district forum has jurisdiction of 20 lakhs up to 20 lakhs. The state commission in every state has jurisdiction up to 1 crore. And the national commission has jurisdiction above 1 crore. So assuming that you buy any flat in a city like Mumbai, even a 1 BHK flat costs more than 1 crore rupees, and your the jurisdiction or the authority, the value of the services as a whole has to be taken while determining a dispute under the Consumer Protection Act. There is a judgment of Ambrish Kumar which says that your value of the flat along with your claims have to be clubbed together for the purpose of deciding the jurisdiction of a tribunal. So mostly it will fall before the National Consumer Forum, which is in Delhi, and it becomes an expensive affair and a long consuming affair. And whereas
even
and
for home buyers associations to get together, it might not work out really fantastically or really well, because even if you have your representative go and come back and all, it still costs.
It's a good forum. The consumer forums are good forum. A lot of reliefs have been molded in particular circumstances, and very good reliefs have been provided by the consumer forums all throughout the while. Considering the fact that this law under Consumer Protection Act has evolved, and RERA is a comparatively new act. So these decisions are varying from say 10 to 15 years, and on the basis of judicial precedents, the law has evolved very well before the consumer forums. But the only issue is the filing. Filing is also not an issue, but the issue is being there. Somebody going, if your advocate is based in Mumbai, then he may have to travel to Delhi and incur cost and time and all those things.
Right. There's a question here on whether an SRA project, slum rehabilitation area project, SRA redevelopment project requires to be registered under RERA?
See, of course, if the saleable area is being promoted by the developer, in my opinion, it requires to be registered under RERA. Section 3 does not differentiate or distinguish between a redevelopment project or a SRA project or a completely fresh or a saleable project. So, of course, your rehabilitation component is excluded because it's a rehabilitation which has been provided to the slum dwellers. And if the area exceeds 500 square meters or the parameters laid down on the Section 3 is complied with, then of course it is mandatory for a developer to promote a project. Otherwise, also, you see if SRA projects are left out, then in a city like Mumbai, most of the projects would not be under the domain of registration and RERA. A lot of huge projects are being registered under marketed and promoted under the slum rehabilitation scheme.
Right. So the other question is like what are the kind of projects which are not required to register under RERA? So what are the ones that would be out of it? Let's say completed, done, dusted, not supposed to register when RERA came into place. So what are those categories of projects?
See, I think Section 3 is very clear in that respect. It excludes the projects where the area of the plot is less than 500 square meters, where the apartment which is sought to be promoted, where the apartments do not exceed 8 in numbers, and where the occupation certificate has already been received. Occupation or completion certificate has been received before the act coming into force. And lastly, when a project is not being a building or a project is being redeveloped or revamped, or repair works are being carried out, which do not entail marketing, promoting of any areas in the
project. Right. So again, there is an interesting question here which is related to the COVID-19 situation that we are facing right now. And I think the connected question here deals with an extension of registration. So all projects have an expected completion date. You are able to see the expected completion date on the website of the RERA. But now, given this situation, if you have, let's say, applied for an extension, and because of this situation, you weren't able to get the extension, i.e., you could not get the RERA didn't confirm the extension of the project. Now, what happens in such situation? Because you stated a certain deadline to deliver the project to people, and you applied for extension, but you didn't get it from RERA. So extension is another extension of registration.
According to me, the biggest issue that is going to be faced by developer in these COVID-19 times is going to be the issue of extension of registration. So a developer, if you see a project registration, it states three things. One is the proposed date of completion, which is the date which has been promised by the developer at the time of the sale. Second is the revised proposed date of completion, which is the time promised or stated under the registration by RERA. The next is extended date of completion. So this extended date of completion comes into force when an application is made by a developer under section 6 to the authority in the event of a force majeure, and the authority under reasonable circumstances, considering the facts of the case and going through the fact that there is no default on part of the promoter, can extend the registration of the real estate projects. So as of now, a lot of authorities in the states have given suo motu extensions to a lot of projects. According to me, this power of suo motu extension does not lie with any authority. The only power for extension lies under section 6. Each and every developer who wants to seek extension has to approach the authority. Authority will hear you out, see the case made out by you for seeking an extension under force majeure, and grant you the extension. If in case extension is not granted, then of course you have an appellate forum to appeal before under section 44. If that does not go through, then you will have to approach the Bombay High Court under section 100 of CPC by way of a second appeal. And if that does not go through, then maybe you'll have to approach the Supreme Court by way of SL.
So, if let's say if a builder is seeking extension for a considerably longer period, then it would seem feasible in the circumstances. Like there's a lockdown, so we understand that things got affected for a period of, let's say, 2 months or 3 months or whatever. But if you are seeking extension for a far longer period, is there any limit to how long you can seek the extension for the project, or does the RERA consider this on the basis of the reasonableness of the extension sought?
See, section 6 is very clear that extension can be only given in case of a force majeure event when the application is made by the developer. Another essential requisite that there should not be any default. So that is also one very important aspect to be considered. Supposedly, if you are considering a project which is being, standstill or lying undeveloped for a period of 10 years, then it can't be the case that, a casual extension can be granted by the authority to the developer. Also, if you see the last para of part of section 6, it says the authority can only in the event of a force majeure grant extension, which in aggregate can extend only up to period of 1 year. So a developer may, in view of this COVID crisis, may apply for extension, and depending on the work that has to be carried out and the balance development work which is to be done, the extension can be granted by the authority, but which can only extend to a period of 1 year. Fortunately or unfortunately, that is the law which stands today, and that period will have to be obliged for, because if extensions after extensions are being granted, then the purpose of the act becomes infructuous, according to me.
Absolutely, yes. Yeah, but like, is there any case of discretion that the authority has as regards the period, within the period of 1 year? Like the max cap is 1 year that we get, but is there any discretion that if the builder is seeking extension based on specific circumstances, lockdown for instance, then like if the operations would be affected for, let's say, 3 months maximum, and you are seeking an extension for 1 year, then does the authority have that discretion to say no, you cannot be granted extension for that long?
See, section 6 by itself states that extension can be granted in reasonable circumstances by passing an order to that effect. So supposedly, if the extension was that there was a period of 3 months, supposedly say from March, and now we are in the month of May. So if 3 months have elapsed and the balance completion work is to be carried out by the developer, the balance work which has to be carried out, if the authority can, if the developer can, produce certain documents from the architect and engineer stating that this development work will take so much time, and the authority is of the view that this work can be carried out within a period of 3 months, then accordingly, taking into consideration all these things, the extension should be granted. It should not be granted just for saying, or just if the developer asks 6 months, 6 months directly granted, or a year granted. That vitiates the purpose of extension under Section 6. So it can easily be done, looking at the project registration certificate and the updates that the developer has posted on the website of the authority. There are various places which stipulate how much excavation work has been carried out, how much RCC structure has been carried out, how many slabs have been laid, what is the internal work, finishing work. So based on that, it can be easily determined that a particular project, what is the time period required for carrying out construction if the developer proceeds appropriately with construction.
Yeah. Someone has asked, does a developer or promoter need to register themselves? No, they don't. It's just the project which needs to be registered in case of promoter and developer, right? And it's the real estate agent as an individual who needs to register. So the duty is different on two separate categories.
Yes, but the details of the developer are captured under the enterprises that he has, past projects he has promoted, how many delivered, litigation, etc. So all those details you can have a look at.
Yes, definitely. And then the other question here is is of choice of a proper forum, RERA, Consumer Court, and NCLT, which tribunal should be. I believe in recent times, in fact, RERA becomes more or less the only authority which you can logically approach, right? Because like NCLT now has been made really difficult in the sense that it has to be 1 crores, and then it has to be 100 buyers or 10% of the buyers for a specific project coming together in order to be able to file a petition. And next, like, they're also planning to have petitions suspended for a period of 6 months, or maybe 1 year, if that's how the ordinance gets passed. So like IBC becomes a little bit difficult to take. Consumer, as you rightly said, because of the logistics, it becomes an issue. Therefore, RERA remains only logically kind of available or suitable forum in case of the aggrieved bias. Is that correct?
Yes, it is correct. But you see that the Delhi High Court has recently ruled that all the three forums can be taken up simultaneously by a purchaser. So supposedly you are seeking some reliefs under RERA, you are seeking some reliefs under Consumer Protection Act, and you are also triggering the code. It can be simultaneously approached. All the three forums can be simultaneously approached. But more or less your disputes or grievances would be similar under the RERA and the Consumer Protection Act. So according to me, if you are raising similar issues before two similar tribunals seeking similar reliefs, then one of the tribunals or both the tribunals may not entertain your complaint. So you will have to choose before the forum which you have to proceed in respect of your certain relief. And as you said that NCLT, with the suspensions that have come in, the threshold limit being increased to 1 crore, there being a moratorium period, there being a standstill on the functioning of NCLT, it's kind of difficult to approach NCLT. Of course, when the purchasers or group of purchasers want to change the entire management of the developer or the debtor, then they can approach NCLT. But that is also a time-consuming process. You have to basically decide what is the nature of relief you are seeking.
Exactly. Yeah. So there's someone who's asked a very case-specific question now. He's asking, can you enlighten on the Lavasa project, which got litigation for non-registration because it was leased property? I'm not aware of the details of this.
Lavasa, there is a Bombay High Court judgment of Shalini. If I am not wrong, there is a judgment of Shalini Fansalkar Joshi, where they had contended that the property was leased and they had not received considerations, and accordingly the project it does not have to be registered. But and they have said that the RERA is not applicable to them. But the Bombay High Court in the second appeal has held that in fact RERA is applicable, and a developer circumventing or finding ways to change an agreement from a sale agreement to a lease agreement vitiates the purpose of the act, which is not the intention of the legislature, and the project or the lease, which is the subject matter, falls within the domain of RERA.
Right, right. So this is another interesting thing, like offshooting a little bit, not connected directly with registration, but as he rightly pointed out, like in case of RERA, you can have a second appeal to the HC. Like in other cases, most legislations you will find that if you want to challenge the order of a tribunal, you would probably have to go to an appellate tribunal, and you have to go to you can only go to the HC under a writ. Otherwise, you would directly have to approach the Supreme Court. But in case of RERA, there's a second appeal that lies to the High Court. That's an
Yes.
interesting point to be noted here, right? The other, there were a few questions that we received over WhatsApp. Now these are not directly connected with registration, but we can just have a discussion. So in case of delay in execution of the builder buyer agreement, I would believe this means the agreement to sale. Okay, how can an allottee under the RERA ask the builder to execute the builder buyer agreement? So there's definitely a provision requiring the execution of an agreement to sale on receiving 10% or more of the consideration, right?
Yes, there is a provision where you can approach the tribunal for seeking execution of the agreement for sale. And if you are seeking possession also, then you can file a complaint under 18 also. And there are quite a few judgments and order passed by RERA where directions have been given for registration of agreement for sale. And even in some cases, in the event of default, where the developer has not come forward, the authority has by itself executed an agreement with the purchaser.
Okay, okay.
Yeah.
So this is very important in case of ongoing projects, because it's possible that at the time of coming into force of RERA, people have received already more than 10% of the consideration, but they have not executed the agreement to sale. So immediately upon coming into force of the RERA and the registration of the project, they would have to execute the agreement, right?
Yes. It's a statutory obligation on the developer.
Right, right.
In any case, it was. In any case, it was. Even under MOFA, it was 20%. Once 20% amounts were received or realized by the developer was under an obligation to execute an agreement for sale. So a similar provision has been incorporated under the RERA Act, where the developer has to execute an agreement on receipt of 10% of the amounts.
This might not, however, be the case for all other states, but the 10% requirement is applicable now by RERA to all states, barring like West Bengal got their own legislation. But other than that, like the states are all subject to RERA. The second question is that can the allottee ask for the refund even after the builder has transferred the possession of the flat? However, such possession has been delivered after a delay.
See, in that case, you will the purchaser, see, there is a Latin maxim which says that within time, and he does not have to sleep over his rights. So once the possession is granted, it becomes difficult to approach the authority and seek delay for compensation. In my practical experience, a purchaser should approach RERA before the occupation certificate is granted to the project. Otherwise, then a lot of different and diverging views are being taken that you have not come in time. What were you doing? The developer has already offered possession. You have not taken possession.
Yeah.
You are the one who is creating hurdles X, Y, Z. And it becomes, because the developer has a lot of examples to cite that, see, this is the project I have completed. Everybody else has taken possession. So this is nothing but a sort of a gamble or a blackmail which is being done. So contrary views are being taken, but one has to be vigilant enough to approach the authority before the occupation certificate is granted. Otherwise, the authority is of the view that that the possession should be taken.
Right, right. So obviously, like if you are the one who is getting the possession or who is entitled to the possession, and you are not raising it at the appropriate time, that is something
Appropriate time.
that can be, yeah, can be considered. So can an allottee pray for interest for delay in transfer of possession in complaint to authority, where he is also seeking a direction to direct the builder to hand over the possession? Or does the allottee have to file a separate complaint for interest with the adjudicating officer?
I think Section 18 covers both the issues simultaneously together. It's spread across or split across in two parts, where if the purchaser is not satisfied with the developer of the development work, then he can seek the refund of amounts with interest from the time he has paid, or from the time when the possession was promised. In the alternative, the purchaser can seek possession and seek compensation for delay in handing over possession. So no separate complaints in this respect have to be filed. But if in the alternative, like supposedly a purchaser has suffered some losses on account of renting an apartment during the period of construction, then that separate complaint is maintainable before an adjudicating officer under Section 71, where the purchaser will have to make out a case that these are the damages which have in fact been suffered by the purchaser, and he ought to be granted those damages, which the authority cannot grant you under Section 18.
Right. There's one question here from someone who's booked an under construction property, and they executed an agreement to sale with an obligation to give possession by June 2017, and now till date they have not received the possession. Another question I think which was relevant in this same case is the COVID-19 situation actually considered as force majeure, where you can really go and kind of apply for the extension of registration. Now I think this depends on how people interpret force majeure, right, under the act. So like whether this is because it is actually a lockdown and it is not something in the control of either the builder or the home buyer.
Right.
There is no control of either of the people in this situation. So that's a question of interpretation, I would believe. But the options that someone would have, where the project is not registered and the possession is uh, not received, is probably to go to the RERA directly, right, for the possession, and also for for maybe an interest that you have, right?
Right. And this definition of force majeure under Section 6 is very wide. And this period of lockdown can certainly be declared to be a period of force majeure. But if in case the developer is seeking a longer extension, then he will have to make out an appropriate case that the events were beyond his control. And the law of force majeure is very clear on the point that the person who seeks to have a resolution from his obligation or relaxation on his obligation will have to make out a case that the force majeure event existed, which was beyond out of his control. He had no control, and he had by reasonable and necessary means tried to do the necessary things. So once all these circumstances or all these essentials are proved by the developer, only then the force majeure extension can be sought by the developer.
Yeah, someone else here is comparing, the time as far as, the consumer forum proceedings are concerned, and also for RERA, because there can be a longer time that's taken in consumer forum proceedings that happens, while RERA, it may be, a bit quicker. So what is your experience in this? Like, one thing that strikes is RERA you can approach only for registered projects, while consumer forum, I think you can approach irrespective of whether it's registered or not registered, whatever. Where it's registered, RERA might probably be the better alternative to go to, right? What do you think?
Of course, once a project is registered or a project is a registered project, the better option would be approaching the RERA tribunal, because as I told you, there are no limitations, and the court fee is rupees 5,000 irrespective of the fact that your claim be 1 crore, 10 crore, 50 crores or whatever. And
Yeah.
and the entire scheme of things is covered under the act. So it's a appropriate option to approach RERA. But as I told you, that the reliefs are better with the consumer forums, because it has evolved with law. As in, sometimes RERA gives, as of now, I think RERA is giving out an interest of around 9.5% or 9.5% or
Right.
10%.
Right.
But consumer case sometimes gives out an interest of 12%, 18% also has been given out. But
Right.
then again, yeah, the same difficulty as I told you, that you will have to fit yourself within the four corners of definition of a consumer and approach the concerned tribunal XYZ, whatever it is. Here in RERA, the easy part is that you can seek reliefs of all the nature. Everything is more particularly covered under the act, and the RERA tribunal itself is here in Bombay. Now one office is also opened up in Churchgate. Appellate tribunal is in Fort, and second appeal lies with the Bombay High Court. So for a purchaser who isn't based in Bombay, this becomes a more appropriate way of
Yes.
dealing with the litigation. Also with the lawyers, also it's more comfortable and less time consuming. And since we are aware with all these tribunals who are functioning in close proximity, most of the lawyers are aware about the functioning timings and all those things.
There's one more question which is kind of relevant, not for Mumbai, because uh, one of the places to quickly adopt RERA and get all the rules in place was Maharashtra. But in other states, this might be a bit relevant, okay, where there was slow adoption of it. Now, if there weren't model documents that were there, so when you register your projects, there are always, the states have provided for kind of model agreements to sale and model documents that are there that the builders can use for their projects. Now, if that is not available, then how do you go about it? And is it mandatory to use that? You can use as near to the model as is possible without contravening any of the provisions of the act. So, what's the criteria for having the agreements properly in place?
See, the model agreement stipulates that a developer have certain terms and conditions and clauses incorporated, uh, you know, uh, being them in line with RERA. But otherwise, also I feel it depends on a project to project basis. With the act being in force, the developer who is promoting and marketing a certain project will have to scrutinize all the provisions of RERA and the permissions that he has, and what are the necessary requisites that he has to comply with. So if a developer wants to stay out of this legal issues, then he will have to take a full-fledged opinion from a lawyer, maybe how his project how his agreement for sale, depending on the title he has, the land which he is promoting, the permissions which are necessary. Opinion will have to be sought by the developer for with respect to the project, that how certain necessary clauses have to be there, and how his agreement has to be in force or in line with RERA, be it with respect to the common areas, parking areas, or the carpet area, etc.
Okay. There's one more question which was, I think, asked before and which is very relevant, is that at what stage do you actually register the project with the RERA? So now, naturally, you have to do it before you actually go out and market a new project. But what are the kind of approvals that you have to have in place? There's a list that's there in RERA, but is there something that can be taken after or during the registration process, or there has to be certain things in place for you to be able to apply for a RERA registration?
Can you please come again?
So, what are the approvals? There are, someone has told me that there is something like 52 approvals that you actually need to get a project running and off the ground, right? So you have to have your project cleared as far as the building plan is concerned. That's something somewhere where it's near to the highway. You have to get that clearance. You have to get clearance for related to forest purposes where that's relevant. You have to get clearances which are related to water. So, what are the things that you have to have in place Okay, the approvals that you have to have in place before you register your project with RERA, or are all any approvals that is required for taking for lifting the project have to be in place before you apply for the project registration with RERA, and there is nothing that can be done during or after.
No, if you see section 4 read with rule 3 is very clear that the commencement certificate and sanction plan, layout plan, and all the permissions from the competent authority as the case may be are necessary. So these documents are of vital documents, the legal title of the developer, the area of FSI to be consumed, the nature and number of buildings, apartments, all these have to be disclosed by the developer. But it certainly depends on the area of the project, the nature of the project, and location of the project, that what are the permissions which have to be required to be taken. So it's a very exhaustive list which we cannot define, and which can only be taken in account on a case-to-case basis. There are a lot of permissions necessary. There may be CRZ permissions, there may be permission from the collector, there may be permission from Mahada, there may be permission from defense, there may be permission from railways. So it all depends on the title of the land you have, the location of the land you have, and the nature of development that you are carrying out.
Yeah, but all of them have to be in place before you apply for registering.
Yes,
Because
mostly see
after registering, you can market your project, and you are not allowed to market your project until you have everything.
According to me, once all the permissions are with you, only in that event your plan will be sanctioned. You will have a startup certificate from the authority. So if supposedly say some permission for aviation is required in some places which are close to the airport, so unless you have those certificate, the BMC is not going to give you a commencement certificate. And even if it is given, then it has to be renewed, which will have to be updated with the authorities in due course of time. So unless those compliances are there, you may not be able to, developer may not be able to, fully carry out and complete the project. Of course, in some projects, there is a issue of permission, or permissions are given in a phase-wise or a staggered manner. But all these compliances have to be complied from time to time for getting permissions, for proceeding with the development and construction of the projects.
So RERA is to be approached the last of them all.
Yes.
Like you have to have everything in place.
Section 3, the purpose of having Section 3 is that you are putting your project in a public domain, where a purchaser or interested person can see what are the permissions that you have. And on a developer complying with all these provisions, he is given the registration under the Act. So the purpose itself is that that the developer who promotes or a purchaser who purchases has to have a clear idea of everything that the developer is going to offer to you.
So someone is asking, can a project be RERA registered with IOD or only after the CC, which is completion certificate?
A project can be RERA registered with
IOD. I'm not sure.
Intent of disapproval.
Okay.
So, it will along with or after. See, on the I don't think on the basis of IoT the project can be registered. Once the commencement certificate, which is given pursuant to the compliances which are pointed out under the IoT, are complied with, only then a commencement certificate is given by the municipal corporation or the competent. So all these, this is the practice which was sought to be curbed by the parliament. Earlier, developer getting an IOD is not a big problem at all, but getting a CC after complying all the provisions and obtaining necessary permissions is where the task is and where the hassle lies with. So IOD can be obtained in a period of 3 months with respect to a particular project, but complying with the compliances given under the IOD itself is a task after which a completion certificate is granted.
So there's another interesting question here. So someone is talking about, can registration be cancelled? Now it's like one part on whether the authority itself can cancel the registration, and the other part is if something goes wrong from the part of the builder, can the registration be withdrawn, right? So these are two things that can be relevant.
See, section 7 provides for revocation of registration of project. Suo moto by the authority or on complaint by a allottee or a group of allottees or a organization of purchasers, etc. So
If incorrect details are submitted for registration or not, definitely there has to be a
if
there has to be a power.
it may be incorrect details, or it may be the fact that the developer has changed certain amenities, not complied with the plan, has engaged into unfair trade practices, promised something, not done that. So on it depends on what kind of a case a person goes before the authority. But the scheme is very wide that the authority may suo moto for non-compliance of the provisions of the act, can revoke the registration of a project. Also, allottees can purchase the authority under Section 7 by making out appropriate case for cancellation of registration. And then consequences under Section 8 follow. Once the registration is cancelled for lapse of registration of a project or by cancellation by the authority, then the authority bars the developer from accessing the site, registration of the project in the site of the authority, and the completion balance completion can be taken up by having a word with the allottees, and it may be given to some agencies or the association of the allottees as the case. That is what has happened in the case of Amrapali. Supreme Court has cancelled the registration of Amrapali, and some authorities, local authority based in UP, have been given the power to carry on with the balance completion, receive the amounts, and hand over possession. So it's a very interesting concept, which has not flown off much as of now. But maybe with the crisis in the segment, all these things may come into place at a certain point of time from.
And then the other question is withdrawal of registration by the developer or the builder themselves. Now, you're let's say you're within your project completion date, it is not passed, and are you able to withdraw registration? So, because you are mandatorily required to be registered by the RERA, and it means probably that you don't want to continue with taking on the project. Can you withdraw registration? You got all the approvals and then you applied with RERA. Can you withdraw registration now?
Tell me who would want to withdraw registration of a project?
Pardon?
I'm saying, tell me who would want to withdraw registration of a project.
Let's say a builder has kind of got all of the approvals, everything is in place.
Because registration, the developer loses his right. If he withdraws the permission, he will be faced with a plethora of legal proceedings, criminal and civil, that he will be burdened with, and the developer also must have invested some amounts, at least some amounts. So he would withdrawing by himself, he would lose all his rights in the project and invite a plethora of litigations. So a developer would rather want to get the registration revoked by the authority and get out. But even in that case, Section 18 complaints are maintainable against a developer. Supposedly, if he is not able to hand over possession, then according to me, till the time possession is handed over, this obligation or liability is fastened on the developer. So tomorrow, supposedly, a registration is revoked in respect of a particular project, and possession is not granted. So till the time the possession is handed over, he still suffers a burden of handing over, making payments of the interest and compensation.
Yeah, so there's a question here about the COVID-19 situation. I think we had this discussion on whether it is covered under force majeure or not. Like if it's, I don't think it's relevant in that case whether it is a natural calamity or a man-made situation. Is it like is that the basis? Because that's something that for contractual disputes, you I think there it depends on the language that's used in the contracts, but I'm not sure if in this case for extension purposes, you would consider whether it is a natural situation or a man-made situation as an argument for delay in or extension of the registration of the project.
See, according to me, the definition under Section 6 of force majeure, which is appended to the section, it's a definition of a very wide import, which covers man-made as well as natural causes of force majeure. So there can be there are examples of war, fire, and epidemics and all those things. So it's a very that the authority who is interpreting this provision will have to give a wide meaning to the import of the definition, and certainly this can be included in force majeure.
Yeah, yeah. So I hope that answers your question. Uh, the other one is related to charges and all, but I think this is not directly relevant or connected with registration. We are already crossed, 5-6 minutes of the time. Another question is related to insolvency declaration by the builder. I think all 7, 9, and 10 application 10 is the one where builder can apply for their own insolvency as a corporate debtor to the NCLT. But I think all of them are the government is looking to suspend all three of them for 6 to 7 months. So that's going to be a bit tricky or a bit difficult to deal with as far as NCRT is concerned, right? So there is another question on criminal liability for use of defective material. I think these are not all directly connected with registration. So I think we have dealt, quite a few issues as far as the registration of projects under RERA is concerned, and I don't see any further questions that are coming for that. So thank you so much for dealing with this topic, which is very relevant, particularly for builders who are facing real practical issues when they actually go to register their project. There's another last minute question. So this is the last question we'll take, which is after paying 10% payment in a RERA registered project, if there is cancellation done by the developer, as we just noticed, is not going to cancel. It can be the RERA who cancels the registration. Okay, so as the reason, then what's the refund remedy now? So the registration is cancelled by RERA. This is a relevant question, because if the registration is cancelled by RERA, what happens to people who already paid money to that builder for their units?
See, the developer loses his right in respect of the project and not the purchasers. So their right remains intact in respect of that project. And that is when the consequences under Section 8 follow, where the authority can appoint a competent authority or a group or association of purchasers for completing the balance project by, either by pooling in the monies or the monies which are lying with the accounts of the developer or the receivables that are to come in. So carry on the balance completion and possession can be handed over.
So that is very relevant. So what you said is very relevant, that the allottees continue to retain their rights under RERA despite the registration of the project being cancelled, because only the builder loses his rights. The allottees retain it. Is that correct? Despite the project not being registered.
Yes. That is the entire purpose of the act, right?
That's right. Okay. I think we have covered, the aspect of registration in a very comprehensive manner, and we dealt with quite a few questions that were related to registration. Thank you so much for dealing with all of these queries patiently, and actually bringing to us the issues or real problems that people face while they are talking about registration of the project, or why they are going to seek remedy with the RERA. And we will look to have more more webinars which are related to RERA or RERA procedure or real estate issues later on. So thank you so much for attending this webinar, everybody, and have a great evening.
Komal, just before signing off, I am just putting my link of LinkedIn, where I had shared the details of this webinar. So I
Yeah,
would request everybody, if you like the webinar, to either like the link, or comment on the link. And if they have any personal questions or queries, they can out with it. So I've just shared the
definitely.
link on, yeah, so they can
Definitely.
give their comments and likes maybe on, or raise their issues, or if they have some personal uh, queries or something, that they can directly raise up with me.
Definitely, definitely. You can reach out to Mohammed Zain Khan for all of your queries that are related to real estate projects and all. And if you know, if you want to know, what he did, then I can just place this link here for all of you to take care. And you can have a look at this course here, which Lawsico offers, and which also, like has been undergone, which Mr. Muhammad Khan underwent with us. So thank you so much. Have a look at that. If you are interested in the course, or if you want to know more about, there are other aspects which are related to real estate. Other than registration, you would have aspects that are related to financing of real estate projects. You would have aspects which are related to how to acquire land with respect to real estate projects. You would have aspects which are related to what goes into joint development agreements, or commercial lease agreements. Have a look at this course. We are kind of having all these aspects of comprehensive connected legislations also with the real estate covered into the course. Please do have a look. If you have any queries on the course, you can reach out to me on my number. I'll put it down here. Okay. If you want to have any queries on the course, or if you want to know if something is included, is not included, if you would like to undergo the course, you can reach out to me on this number. I'll give that a moment. Okay.
I'm also sharing my number, so that anybody who wants to reach out to me
Yeah,
can do
sure.
so.
Sure. Please put it down. So that are both of our numbers. You want to reach out to either of us for any real estate related issues. Thank you everybody, and good evening, and have a nice evening. Have a nice day. Bye.
Thank you so much.